Mark Stevens, author of Adventures in Legal Land. Welcome to the No State Project. This is not broadcast live. We have some technical issues that we will get taken care of. But hey, Calvin, who's joining me, of course, wouldn't be the No State Project without a tech issue.
Yeah, it's commonplace here, but we keep treading through, so.
Yeah, that's just par for the course. I apologize for that, but it is June 16th. It is from the Fortified Compound here in Phoenix, Arizona, and I want to get right to it because I know she's very limited on time. We're trying to get her prepped. Mary from Michigan joins us again. Welcome back to the No State Project, Mary.
Thank you, Mark. Hello, Calvin and Mark.
Yeah, I'm glad, and we're glad to have you on. And you were the one that 5 police officers in Michigan knocked you down, basically tased you, and I think you were also hit.
I wasn't hit. I was maced. Well, I was grabbed, put to the ground, and I was maced at least twice, and I was definitely tased at least twice as well.
Yeah, now you have the video available. That
I do.
I love to have, get it posted. I don't know if you could put it on YouTube, and then we can embed it on my website at markstevens.net. But I have seen the video. I was very surprised at how clear the video actually was. Now, you've usually when you see the surveillance videos, they're not nearly as I'm not saying it's high def, but it was certainly at a very high quality, and at least to me, and I think it's important for other people to see it, so it's not just me or your opinion of the video. It seems pretty obvious to me that the police officers were the aggressors, not you.
Definitely. Yeah, I was at no time aggressive, not even calling names or yelling. It was totally uncalled for.
It stands to reason that somebody who, who's surrounded by 5 armed police officers, who, of course, was not on any kind of hallucinogenic, would actually attack the police officers. I mean, yeah, maybe it's me.
Yeah, I mean, they have guns, they have uniforms. My brother was there as a witness, and he was just, come on, guys, leave her the F alone. I remember hearing that after I was pretty blind from the mace, and I'm really glad that he was able to maintain, emotional control and just be there as a witness for me rather than jumping in and getting thrown in a cage as well that night.
Yeah, well, I have to ask, and this is in light of the fact that I have left messages with the Hudsonville Police Department and a courthouse where that happened and let them know that I was from the media and I wanted to hear their side of the story, if any, what they thought about what had happened, and they never got back to me. And I did put in the article that I posted on the website that I have not heard back from them. I gave them an opportunity to respond, so we only have your side. However, there is a video to it now, so it's not just, what you have to say. It's backed up by video.
Right.
You don't have, have you had any other altercations with police officers where, something like where they've attacked you or they've accused you of attacking them?
No, this is my first experience of really interacting with police officers. Before this, right now I have a driving on a suspended license that's pending, and then I have now the PO assault /resist/obstruct that they're charging me with.
Right.
And, yeah.
Now, one of the things I want to do today, and I know you've gotten some help from, and I appreciate the help that you've gotten so far on the No State Project chat. And anybody who wants to get into that, of course, you can Skype me at FrankRizzo3, and then I can add you to the chat, the No State Project chat, and then you can meet with some of the people that are there, and you can form another chat group or one of the other ones that are already there. They're actually starting to get filled up now, Calvin, where we're going beyond the 24.
Yeah, we're getting past the limitations for even making a conference call now.
Yeah, we're probably going to have to maybe use the free Conference Pro because like what I use for the show, because we can get we can get a lot more than I don't think there's such a limit on it that way. So maybe that's something we can use for that. So again, you go to Frank Rizzo 3 on Skype and we can get you in there. But we want to. I understand your apprehension about what's going on. So we want to get you prepped. So real fast, what happened was your prelim got postponed until this Thursday?
Correct. The prelim is this Thursday. Yes, because originally I was going to waive the prelim, and then I made a last-minute change, and that threw them off, so they didn't have any witnesses ready to go the next, within an hour. They had to get witnesses ready, so they adjourned the prelim until this coming Thursday at 8 a.m.
Okay. Now, I understand your apprehension here. I do, because you got a number of issues that we don't have. A couple of things like with the public defender, which is unfortunately involved here. where we don't know, and you don't know if he's going to challenge the elements that you would like to see challenged. Elements that
I don't see it happening.
We can guess. We can guess.
Yeah, he's a state man. So what we want to do is get you prepped so that and help you get prepped so that you can go in and do that. Now, I've been through it many times. I've helped other people quite often, and Calvin is also fairly experienced at this. I mean, you just had something last week, correct, Cal?
Oh yeah, emotions hearing where it was just blanket denials. He carpet bombed me.
So I do want to talk about that, but not more, not for this hour that we have with Mary, because she's got this thing coming up on Thursday, and she's probably going to have to do this herself, or at best she could do it herself with the lawyer there as basically like standby counsel.
Standby advisement, right?
Right. So before we get into some role playing, and Cal is really good at this, Mary. So if you've heard some of the one, because Calvin, you have it posted on the website, the last.
Oh
one.
yeah, but it's less skill. I mean, these judges really they give you all you need to know to how to act like them. It's just if you know how to act like a child, it comes naturally. If you're, we've all been 5-year-old once. You just have to regress a little bit.
Well, that's true, but the role-playing has helped you be more confident and stand on your feet when you're in the lion's den, so to speak.
Oh, that's absolutely right, because they often try to trip you up in questioning, and so the more you can prepare yourself for when they throw you off course, you can learn how to bring them back on course, and so they don't just leave you in a whirlwind of confusion. They're pretty good at that. It's about it, though.
Well, yeah, they are very good at that. So before we get into that, though, Mary, what I want to first address, and it is very important, I appreciate you taking your time to do this, because a lot of people are in the same situation you're in that they're being attacked in some way, and they may know the material fairly well, but it's getting over the apprehension, the fear of the because you haven't done it before. It's got going in there, and because it's your life on the line, and so we can help you be more confident and prepare you that other people can see, like, look, she's not a lawyer, she's not in court every day, and if she can go in there and do it, well, then I can.
Right.
So I want to start off with your initial questions and concerns, and so that we can then answer that and then use that and focus on that when we do some role playing.
Okay. As far as the role playing, I did a little bit with Vin and Dan last night. They were definitely helpful last night as a prosecutor and a judge, and I heard them once, and then we went ahead and I went through it. So it's definitely a confidence builder to be able to make sure you know the stuff before you go in there and try and do this yourself, because they will try and intimidate and scare the living crap out of you.
Oh yeah.
Yeah, you gotta be prepared, and I really appreciate the help in getting prepared, because it's going to be nerve-wracking firing my lawyer if that's what ends up going down, or yeah.
Well, first seek to have, and we spoke about this, of course. First seek to have, if he's not going to do that, see if they will allow him to be there just as standby counsel. Like, I think that's the phrase that they use, so that if you do have any questions on procedure that you're not familiar with, that he can counsel you, and assist you on that. So that, because I think that with a lot of people, and I'm going to, I'll assume that this is the same with you, having your lawyer excluded from the proceeding, as much as it doesn't, intimidate me at all, it can affect you, because now you're standing there all by yourself.
Right. Hopefully I will have a person, possibly two people, like, sitting, witnessing, hopefully. I'm not sure if that's like an open proceeding where just anybody from the public can come in.
Sure.
I'm not sure.
It is. It is. Oh, yeah.
Okay.
No, it absolutely is. So if they try to close it off from you, then you've got a problem. You've got a real problem. The grand jury proceedings are not public, but these are all supposed to be public. So if they're going to do that, that's something you definitely want to question. I doubt that's going to happen, though.
Hey, Mary, have you gotten any feedback or any media press on this locally?
No, I have not. My brother suggested, why don't you call a news anchor, call and try and talk to somebody. I'm open to that, but I haven't gone looking for that because I'm not sure where to begin, and I doubt I'll be taken seriously because the media is kind of a mouthpiece, of the government to some degree.
Well, a tip is there's municipal papers, there's small town papers that have some pretty good journalists that will would be interested in sitting in. Some of them have here with me, and they could write a little piece in a journal. That way, you at least have some publication. Sometimes you don't have an online backup, which kind of stinks. But if you get it circulated in your community and get some, at least a few readers interested in what's actually somebody's actually asking the pertinent questions.
That's a good idea.
Yeah, the stories of police brutality and whatnot usually do get picked up. You have video. This is huge, just like the Kelly Thomas video. Yeah, there's video of this, Mary. So I would, you can do a lot of it online, of course, and send, get the video uploaded to YouTube so that you can just provide media outlets with a link so they can go, they can see that. Because if something like, and you don't, and obviously I'm sure you have editing software, you can just edit out, because at least half the video doesn't show what's actually happening. It's only what they did to you takes place in just a few minutes of the video.
Right. And there's different sections where you can see like people watching from the hallway, and there's probably about an extra 15 minutes where, I'm not on camera for those 15 minutes, but it's just like after we left the counter, there's an additional 5-10 minutes after that. So,
well, what particular issues, what questions you have, for when you go in there? What kind of issues you should address? I mean, what's your main concerns?
My main concern is my confidence in myself. I think I know the material well enough to, I understand what's going on. I understand why I'm asking certain questions and the reasons for those. I have a pretty clear understanding of that stuff. I'm just nervous, like I'm going to get railroaded. And I think that going through a couple of role plays will definitely be beneficial. I do have kind of a list of questions that I'm going to have prepared, and I know the evidence of a complaining party being asked to the prosecutor is within the top 4 or 5 questions, depending on which ones, which ones I ask and what.
Sorry.
That's a good place to start. Is what issues do you plan on challenging, or what issues do you plan on questioning the prosecutor and the judge?
Well, I first want to ask if I'm entitled to a fair and meaningful hearing, and then I want to ask if I'm entitled to responsive answers to my question, meaningful answers, yes or no, and then am I entitled to know the nature and cause of the charges against me? And if there's something I don't understand, will you explain it to me? And then ask who's the burden of proof, and then the evidence of the complaining party. Is there evidence of a complaining party, and who is that complaining party? Under whose authority are you here? And then the conflict of interest. I don't know if I want to go into the conflict of interest. I don't even know if it'll get that far, because I want to ask, really. I want to put this.
It may not, but when you bring up the evidence of complaining party, what are you prepared to say if they say the evidence of complaining party is the state?
That's the stuff I'm going to need help with. Like, I know the questions and why, but as far as responding it without going overboard, and because I don't want to turn around and start answering their questions, because I know they're going to try and railroad me and demand that I go ahead and plea, and I just want to make sure I am prepared for that.
Well, to jump in now, Calvin, you had Mary fall right for it. I don't know if that was your intention, but what I got from it was that the typical response that you get when you ask if there's evidence of a complaining party is to say the state. That's not a responsive answer. Mm-hmm. If you're asking, is there evidence of a complaining party, the only responsive answers are yes or no.
Right. And if they say yes, and then I would ask, who is that complaining party? And then they would say, state.
Not yet.
Huh?
Not yet.
Not yet.
You want to know 2 things. Who's giving you this evidence, and what is it?
Oh, yeah. Not just ask them outright who it is, but understand factually what that evidence is, and obviously they don't have any, so...
Well, and who's bringing it? Who brought it? Who's presenting it?
What is that evidence? Who's bringing it?
But even before that, you want to... I think it's important for the issue of jurisdiction. So I want to kill 2 birds with 1 stone here. I planned on bringing this up also on the show. I might as well take this opportunity because I think it's something that happens all the time. I get emails like this constantly, and so apparently it bears repeating. People are under the impression that the burden to prove jurisdiction, that they go in and they want the judge to prove the jurisdiction. And that is not an accurate way of looking at it. The one who has the burden of proof is the prosecutor. The judge's obligation is to presume that there is no jurisdiction until the prosecutor meets his burden of proof. So it's always keeping, and to me, it's more of putting the prosecutor on the spot where it's easier for the judges to make a decision. I mean, we know they're corrupt, but it's easier if you focus the attention on the prosecutor where it belongs. The burden is his to establish jurisdiction, not the judge. The judge is only to make a determination based on the evidence that is brought to him, and that is to be brought to him by who? The prosecutor. And the prosecutor here, if he's going to say yes, that there is evidence of a complaining party, or the judge jumps in and says yes, there's evidence of a complaining party, then the next thing to do is, really? I'm not aware of that? Who brought this evidence and what is it? Or you could just take it in one step. Oh, excuse me, I'm not aware that anyone's brought such evidence. Who are you talking about? Who is the one bringing this evidence? Then once you establish who it is, then you can find out, well, what the hell is he talking about? What evidence is he bringing? And what's interesting and what's very effective here is when they're talking about evidence, if you have them constantly feeding back your word that's evidence, you've now got them committed that there's evidence of the state, which is not an opinion. Evidence is facts. It's people, place, things, events, things that have happened, things that have actually happened that can be proven. So it's great anytime you can get them talking about evidence. I mean, hell, especially with the IRS, if you get that. But then again, Calvin, they've shown me just recently evidence or no evidence, which I will get that on the call of shame.
Oh, yeah, and Mark, I think that's a really good tip, a valuable tip that you just said, as far as keeping the burden on the prosecutor, because a lot of times when I'm in court, I find that the judge starts acting as a prosecutor and making the prosecutor's case for him, especially when I bring up this very issue, evidence of a complaining party. And how would you best recommend to remind the judge that it's the prosecutor's job to provide this burden, not his, and that he is only to make a decision whether or not the prosecutors actually factually establish this burden? What's the best way, do you think, to bring the judge back around to that perspective of actually being a judge?
Just asking him. You just ask him, and Mary, you can see this is in the script. You ask him, excuse me, sir, who has the burden of proof in these proceedings? He's probably already told you, depending on how the situation has gone, that the burden of proof is on the prosecutor, and so that you can point out again. So I don't understand why you keep answering for him or her.
Well, can I tell you what they respond with me, Mark? Is they say, I'm just trying to help you out here. Is that the state, and then they'll go on doing the prosecutor's job for them because they assume that that they have jurisdiction based on just based on them saying that it's state. They don't even the judge feels that he doesn't need to prove it to me. He just says, well, look, you are within the state, and he just leaves it at that. He takes it upon himself, and even though I remind him, it's the prosecutor's job, they just look at it as, oh, well, I'm helping you out. I'm explaining to you this is what it is. Now, next question, and they seem to just to push the issue. Right. That's what I get here.
And I thought I'm fairly sure I've mentioned this before, and I'm pretty sure that I've mentioned to you, and I'm glad you brought it up because I can say what I would say, and that's actually a response that I have in Adventures in Legal Land, and I could just add, like you're saying, well, you're helping me. Okay, great. So you will be getting in a witness chair for cross-examination.
That's a contemptuous remark.
So like I wrote in Adventures, I've said to them, excuse me, are you going to be getting in a witness chair and be subject to cross-examination? They said, well, of course not. Then could you stop testifying and acting as a witness?
That's right.
If you're not willing to get your butt in that witness chair and subject yourself to cross-examination, I would really appreciate if you kept your mouth shut. I mean, I didn't say it like that. I didn't say that last part. But I have said to them, if you're not going to be subject to cross-examination, you need to stop acting as a witness. That usually gets them to back off, at least initially.
Now, is there a good technique to get them to remain, to keep acting as a judge, just as a decider, whether the prosecutor has really provided a factual burden of proof? Because even if you get him to stop submitting testimony, he's still going to, buy the prosecutor's line, hook, line, and sinker, regardless. So is there any way to where you could remind him that the prosecutor has to factually establish this burden? Because,
yes.
And what's the best way to go about that?
Well, you ask him point blank, sir, are the accusations and opinions of the prosecutor admissible as evidence against me?
Okay, obviously no.
And they'll say, well, no, of course not. So whatever he says, to have any validity at all, has to be based on the testimony of a witness I can cross-examine or evidence I can challenge. And that's usually enough.
Yeah, I guess he gets the idea. All right.
So a lot of this through this, and you want to keep this in mind, Mary, the easiest way that I know of to teach this is the model. It just consists of going from the vague to the specific. And everything that you're doing is based on that model. They're giving you something that is abstract and very vague, which you and I know from a little bit of investigation and empirical investigation. There's nothing there. So the more specific we get them, the more frustrated they're going to get because they're going to start to realize there's nothing there either. It's just like when you start deconstructing this fiction that the judge is somehow fair, impartial, and independent. Those words are just that. The facts don't bear that out at all. So you're just taking. So the facts are what's specific. So as specific as you and I can get is that this man is forcing you to answer another man's complaint. That is as specific as you can get, and those facts speak for themselves. The vagueness is that he's a fair and impartial decision maker conducting a hearing. A fair hearing. So we're just deconstructing that. So whether it's his impartiality and independence, or that the cop is representing the state, those are vague, abstract concepts that don't stand up to examination and being specific. So if you remember that, that'll really help. And so if you remember a lot of what I do, especially like with that thing with Philip Mangione. I said, and I repeat this ad nauseum, I know I say it a lot, but hey, when you're investigating and asking questions, you need precision so that you can move on. And I always ask for a point of clarification. Well, excuse me, point of clarification, just so I understand we're on the same page of what you're saying here. And so to get back to this specific situation that we're talking about, if the judge is insisting that there is evidence, just ask him to disclose it. Who gave you this evidence? Who are you relying on, sir?
Right.
Hey, Mark, and one thing to add is a lot of judges, especially where I'm at, have always said, well, this is a matter for trial, so what would be the proper response when they tell you this is a matter of trial and not for pretrial discovery or disclosure?
Sir, are you going to proceed without jurisdiction then? Just a point of clarification so we're all on the same page. Are you proceeding knowing you don't have evidence of jurisdiction?
Or that jurisdiction is at least in question?
Oh, of course it is. It all goes to jurisdiction, which should be the very first thing that should be challenged.
Well, there's something that you mentioned to me, too, is that it's a violation of due process to force something into a trial that is really a matter that could be resolved in pretrial.
Well, it's bad faith at the very least. Now, another thing I wanted to mention on the show today, we'll have Rich call in next week. This is a direct quote. At least this is what Rich is relaying to me that the judge wrote as far as grounds for the denial of a motion. The court is not required to explain its decision, nor are we required to explain the law to you. Now, he wasn't asking for the law to be explained. He just wanted the grounds on which the decision to deny the motion was based on. He says, the court is not required to explain. Now, you're probably all asking, what the hell does this have to do with what they're asking you, Mark? It's evidence of bad faith at the very least, and something's being concealed. So when they tell you that jurisdiction is a trial issue, they're lying to you.
Even by their own standards of legalese and...
Yes.
Yeah.
Absolutely. Yes, jurisdiction can be raised at any time, even on appeal for the first time. Yeah, I understand that. But nowhere does that mean it is an issue for trial only or an issue for appeal only. Jurisdiction can be raised at any time. So the fact that this guy is saying to you, Calvin, or maybe they'll say that to you on Thursday, which they very well might, they're lying to you. They are lying. And so the best way to do is call them on that BS. Remember, we know it's a lie, and we don't want to just come out and say that. So that's why, because you're taking a burden of proof upon yourself. Remember, your statements give you a burden.
Yeah.
But not if you ask it in the form of if you put it in the form of a question, because when you put it in the form of a question, you're leaving the burden right where it belongs. That's on the one who's making the affirmative statement. So when they turn around and say, jurisdiction's an issue for trial, they are lying. Well, just to clarify, sir, just correct me if I'm wrong. Are you knowingly proceeding absent evidence of jurisdiction?
Oh,
I know it's a compound question. I get that. I don't know if the judge is going to catch it or not.
Well, I was going to say the judge will probably say yes. Yeah, I am maybe not realizing that it's a violation of due process.
Well, he's probably going to say no, that he's not knowingly proceeding absent jurisdiction.
But it's bold around here.
Well, it's a type of question. Well, but then you can ask him to clarify it. But you're getting dialogue on the issue of jurisdiction and proceeding without jurisdiction. But it's one of those statements that you're throwing out at him, like, "Are you still beating your wife on Tuesday?" It's exactly the same thing, linguistically. I get,
right.
Yeah. So, look, are you knowingly proceeding absent jurisdiction? And I personally like to do this, Mary, because if I can bruise the judge's ego just slightly to get
that'll ring a bell.
Oh, yeah. You want to do it very slightly just so you get dialogue on it, because you don't want this, "I'm not going to discuss it, move on." You want them to at least start to engage you in some conversation so that you've got something to use against them other than, he just told me to move on, which look, we all know that the judge is, like I say, the judge is the only acknowledged legal expert in the room, and the judge in the higher court or in another court that may be reviewing his decision is always going to defer to him as being right and you being wrong, or especially me. I'm always wrong, so I accept that.
Right.
So if you can get some dialogue on it, it's going to make it much more difficult for them later to spin it and say, "No, that's not what the judge said." Because I learned from experience to always do a point of clarification, because they'll try to spin it later. That's just the nature of lawyers. I'm not breaking new ground here. So that's why I always want the point of clarification. Why I asked John Webb is when he says state of New Hampshire, what is he referring to? The body politic, and then I got cut off because they don't want to get into anything like that. And so you always want them to clarify. So if they throw something at you that you know is BS, get them to clarify it. And that'll usually get them to back off of it.
Yeah, so definitely ask questions rather than making accusations, and get points of clarification as often as you possibly can, and don't let them railroad me.
Well, you want to do the best that you can. Yes, they may still actually do that, because they do have the option of just threatening you and intimidating you, which is not a slight against you. That's the way they do it, and we would prefer to. Yeah, we would prefer. I think we would all prefer that we help you clean it up with a motion to dismiss and an evidentiary, get a hearing on that later to clean it up, than to maybe get thrown in jail and have them change, and change your release conditions, and maybe not release you at all. So, we'd rather see that. But the thing is, when you've got them, like yesterday, I was talking to somebody yesterday. If you catch them in a lie, they're going to get upset. So you want to be very delicate in how you go about doing it. So when you get your clarifications, you can put it this way. And this is like the basis of comedy, is just basically, showing the absurd, which is, let me get this straight. And this may happen to you on Thursday. Let me understand. I just need some clarification here. I'm a little confused, because based on what you've told me, you're a fair and impartial decision maker. And at the same time, let me understand this, you're forcing me to respond to his complaint. Do I have that right? I mean, when you put the two together, they're absolutely absurd. And you just want to bring but if you do that, and in the form of a statement, it loses all its punch, where they can just deny it. No, you're wrong. You want to ask them in the form of a question. Is this correct? Show me where I'm wrong. I just want to understand this. And I get accused, like yesterday, I got accused of being condescending and trying to twist words. And all I did was catch an agent in a lie.
That shouldn't be hard to do.
And this is what happened, just to take a moment to do this. He first told me, and I'm a real prick about this. I'll be honest with both of you guys. I mean, I've told everybody, not only am I usually recording the call, I'm going to use a big word here, copious notes. Huh? I said linguistic earlier, and I used
astute.
Copious notes. Yeah. Oh, yeah. So I'm writing these things down, And I asked the aide, and this goes right to the heart of what you may be going through, Mary, when you're asking about evidence of a complaining party, and the judge is going to try to weasel, and take the burden of proof of the prosecutor. You want to know who he's getting it from. Well, because what do you guys remember? When I'm talking with the IRS, who made the decision? I'm a taxpayer, right? Isn't that like a central part?
Right.
It's the same thing here. Who is the one that's giving you this evidence? So when I'm talking to this agent up in New Hampshire yesterday, live free or die state, the more I deal with people in New Hampshire, these agents, they're no different than ones in California or New York for that matter. And so I get from him right at the very beginning, who made the determination, sir, that my client was required to do this registration? And he says, he did. I said, so I get him to verify. Okay, so you're the one who made the decision, not another department. That's right. So I'm writing it down. Then later in the conversation, where you may go through this, he says, well, this didn't even come through me. This is from the status unit. I wrote it down. So then I called him on it, and the next thing I know, I'm being accused of twisting his words. Oh, okay. So it's very important, of course, that when the judge is going to do something like that, and he very well may do that, Mary, is to find out who he's basing his decision on. Find out who first. Because if you know who it is, then you can start to, because when you go on Thursday, just so everybody knows, even if though it is just a prelim, which are very important, which I'll give some legal advice, never waive the prelim, unless you really did hurt somebody, which of course you didn't. Even though it's just a prelim, you still have the, under cross-examination, you're supposed to be entitled to collaterally attack, by questioning, of course, the competency and credibility of the witness. And when the witness is shown to be incompetent or incredulous, he's not credible, then it doesn't matter if the judge thinks you're guilty, or he legally may not rely on the testimony of that witness. So that's why it's very important to find out who it is so that you can then discredit it. Right. Now you've got, and I'm not trying to minimize what you have to do on Thursday. If you or whoever is doing the questioning of these police officers, I'm telling you, it's very easy to get that prosecutor to declare the witness incompetent if it has to go that far. Okay. When you do, that is the easy part, knowing what to say, but actually being able to deal with the incessant objections. So let me just fast forward here. We'll come back to the beginning when you're questioning the judge. So I want to get to where you're actually cross-examining the witness.
Okay.
Okay. Now, when you have these police officers on the stand, it's very important to build your context, and so that everyone's on the same page, and because what you're doing is you're pulling the strings. You are the puppet master. You're trying to create a context so that you can get this thing thrown out, the whole thing. And we're going to do it based on experience that the prosecutor is going to declare his own witness incompetent. So let's say you're getting to a point where you've built your context, you've had them admit that there wouldn't be a crime if there wasn't a statute, and that you were not within the state on that day, right?
Right.
Because they're going to be thinking physical location, not legalese and abstractions, which is, okay? Well, a few times they get away from the abstraction. So the prosecutor makes an objection. Objection calls for legal conclusion. The witness is not here to testify to that. It calls for legal conclusion. How do you respond to that?
I would respond. So the prosecutors just interrupted me with calling for a legal conclusion. I'm just asking questions here. I'm trying to understand what's happening to you before I can make an informed decision. That's what I would tend to fall back on. And I'm just trying to get answers here. I just want questions answered. I just want to understand.
Well, you got to remember that the prosecutor or the witness's competency was just compromised when the prosecutor interrupted your question and stopped the cross-examination. So that's your cue to point that out, is that he just declared his witness incompetent to testify to specifically legal conclusions, and you want to use that against them. Because that's exactly what he did when any charge that they filed against you is a legal conclusion. It's you broke that law. You violated that legal opinion, not fact, but opinion.
So basically, if I get interrupted there, and you stopped me from questioning the witness. Is he even, is he competent to testify to this?
Yeah, right. You may have to say that. Remember, the questions are geared towards getting that response from the prosecutor and the judge. They'll probably do it at the same time. A lot of people have called the show and they've emailed me over the years, because they're laughing. I had to keep from laughing because it was exactly like you put in the book. They both came out of the chair at the same time. So it shouldn't be a surprise to you when that happens. It may surprise the public defender, but it's not going to, there's this attorney, Sean, from Vegas, who I spoke about last week. He takes it as a badge of honor, apparently, that you can get through an entire cross-examination and not have it stopped. No, that's so because you're going after and questioning and challenging, of course, the competency and credibility of the witness, and then the lawyer is to protect his precious little complaint. His prosecution is going to reflexively say that interrupt you, because it's just like in Liar Liar. They made Your Honor, I object, and why is that? Because it's devastating to my case. So yeah. I think, in my experience, yes, you may want to point out as an afterthought. He already answered the legal opinions. I was asking about the facts, but you want to start off with, sir, with all due respect, if the prosecutor wants to impeach his own witness as incompetent, then I have I have nothing to add.
Yeah.
Not a problem. If the witness isn't qualified to testify, okay. And they go, well, Your Honor, he's not here to do that. He's not here to testify to that. He's only here to testify to the facts. Now, what do you say to that? Your Honor, I object. The witness is not here to testify to legal issues and legal opinions. The witness is here to testify to the facts so that the court can determine if there is a probable cause to bind the defendant over for trial.
I find my guests and this is what I'm worried about. Like, I get interrupted by a prosecutor and by the judge saying this stuff. What to respond when what happens? I can't think on the fly as quick with this stuff yet.
Well, you've got some time. You got some time. You got some time. So that's why we're doing it here. So, Calvin, what would you say? The prosecutor says, Your Honor, I object. The officer is only here to testify to the facts, and so that we can determine if there's probable cause to bind the defendant over for trial.
I'm asking him if he's competent to make legal determinations, and he isn't. You're objecting that he isn't allowed to submit legal opinion. That's what I asked. That's what you objected to initially. And if you've said that he's not able to submit legal opinion, then I would like the whole ticket thrown out. That the fact is that he's not competent to submit legal opinions. He did, and if the prosecutor wants to object to his testimony, then I'll let his testimony rest. And if there's no other testimony, then I would ask that the case gets dismissed.
You said a lot of the right stuff and things that were right. It's just you rambled too much. You say, sir, either the witness is qualified to testify or is not. I think an even better way in that situation is just to look at the prosecutor and say, then why don't, all right, then just go right back to the cop and say, then why did you arrest me? And don't say a word. Just say, excuse me, why did you arrest me?
Okay, all right, because you broke the law. Because you broke the law. That's the only thing.
Okay, and your own and do you realize the implications that your own lawyer is now saying you're not qualified to do that? You're established. So just saying, why did he arrest me? Why do these cops arrest me then? And game set, you've got them. That's it. Now they may want to rethink their objection. There's another issue here too, and it's something that they desperately want to convince you of, and I'm telling you, it's just absolutely not the truth. And don't take my word for this, anybody. You just go research this on your own. Look up who may impeach a witness. Impeaching a witness has to do with challenging the competency and credibility. It's not just what they've testified to on the stand. It's not just that. That's not all there is to it. Because if a doctor comes in to testify as an expert witness, you think he's only limited to the testimony he gave that day? No. It's also an open door to challenge his competency. What school did you go to? All that is on the table. That's why attorneys will openly admit that the reason why their client got trashed on the stand was because they opened themselves up for cross-examination. And that's why smart lawyers will never put their clients on the stand. Because, one, they know the burden of proof is on the prosecution. Two, they know the moment you set foot on that stand, you are opened up to cross-examination. You have to, or all the testimony is stricken. And it's it's easily to verify. I don't think anyone would argue with me, even the guys over at that other site. If you are on the stand and you refuse to be cross-examined, all your testimony has to be stricken, gone. It has to be challenged. And so it's the same thing here. And so the idea, like in traffic or whatnot, they like this, that you are not able to challenge the competency and credibility of the witness against you, whoever it may be, is absolute nonsense. It's a lie, and it should be. And that's why you want a point of clarification if they do that for you, Mary. Sir, are you telling me I am not able to, and you are preventing me from challenging the competency and credibility of this witness?
I think you would have no problem saying, yeah, I don't think this is relevant, and continue on with your questioning. Anytime that I've had an opportunity to cross-examine the witness in my cases, it'll get to this point, and they'll just sustain the prosecutor's objections, and they'll ask me to move on and say, move on to your next issue, and just accept his testimony blindly.
And so you ask him you have to ask him point blank. Are you accepting the testimony of a witness you just declared to be unqualified? I just need you to clarify that.
I think that's right about the point where they start throwing a hissy fit with the contempt charges.
Right. But more important, and just as important, what they usually do here, Mary, and this very well may happen to you, when they get upset like that, what they typically do is refuse to allow any more cross-examination and just make a decision right then and there. Now, yours is a little different. They'll be making a decision to bind you over for trial. But for Calvin and most of the rest of us, the trial's over. They're just going to... that's a denial of a defense. And that's usually overturned on appeal almost 100% of the time. It's over 90% of the time. So we're pushing them into doing that. We're asking questions and putting them in a certain position to do that. We ask the questions, and I have the questions laid out in a certain way. Oh, I engineered them. I engineered
a legal engineer, huh?
Yeah, that's right. So that I would get the judge to, if he's not going to do the right thing, throw it out. I'll take advantage of his rigid behavior and his anger and have him deny me a defense. So this is something I had spoken to with that lawyer, Sean, in Vegas, that he understood and agreed that if the witnesses are declared incompetent and they still bind you over for trial, you've got it's pretty much a done deal. It's not going to trial. You'll be able to get it stopped. So that's what you would be able to do also. So but another thing is, Mary, whatever they're doing to you, that they're trying to railroad you, you can usually turn it right back on them. So if they're going to accept the testimony of witnesses that they have declared incompetent, remember, it's never you. It's always them. Then you can turn around and you could do the same thing by calling your own witness who's not qualified and see what happens.
Right.
Now, this is a very serious issue. So for those who are not familiar, this is a felony, and that's why she's getting a prelim or a preliminary hearing to determine probable cause. There was a complaint filed by a cop or the prosecutor, and I forget which one here. And so because it was just a complaint, there is a prelim, which you should always take. And the other side, if you're indicted, the grand jury investigation, they believe, is what legally takes the place of a probable cause hearing, that the grand juries determine probable cause. So that's why she's able to get, she has that, and it should never be waived. So if it does happen, turnabout is always fair play, they tell me. If they're going to allow an incompetent witness to testify by their own admission, then you just call up someone to do the same thing.
Right.
It doesn't matter who it is. You are doing it to get a response. You want the judge and the prosecutor to get upset and tell you in their anger what the law really is, what fairness is, and that unqualified witnesses may not testify. Yeah. Now we're all on the same page. I want you to throw the testimony out and do the right thing and throw the testimony out.
I got something in the mail from my law firm today that kind of explains what they did. As you know, on Wednesday, June 13th, you informed me that you would like to waive your prelim and call off witnesses. However, yesterday, about an hour before the scheduled hearing, you changed your mind and wanted to hold the preliminary examination. Judge Post and the prosecuting attorney agreed to the adjournment. The prosecutor dismissed your disorderly person charge and amended the complaint to include a disturbing the peace charge. See enclosure. And then I've got count 1 is the assault, resisting, obstructing, and the count 2 is now disturbing the peace instead of disorderly. So they've already switching around and trying to, they're already switching things around, and I think I don't see what the big difference is, and it doesn't make a relevant difference as far as how I'm going to be handling myself. But I see I don't even know what that means, and I was curious about that.
It's basically a catch-all. It's such a vague charge that they have, and you usually, in my experience, you don't see that when there's video of the incident. And here there is video of the incident. And anybody with, and that's why I think it would be good to put it on YouTube so we can get a lot more eyes on it and see who is, if there was a disturbance of the peace, who caused it? Was it a young lady who was just walking out of the courtroom, or were at the 5 aggressive because look, and nobody can watch a video and see that the cops weren't taking right from the beginning aggressive stances with you.
Well, and it's just like with Adamo, Mark, and Judge Burke. It was really helpful for him to have his video of him just questioning Judge Burke when he held him in for contempt and threats for just asking him questions. And when that video went online, he was much more able to make his case, and he also secured money to get to go out on bail because somebody had seen the video and seen how it was blatantly Judge Burke lying. So having that out there in the public domain there's a lot of power in it. Just like challenging the prosecution in the court on the facts. As long as you just stick to the facts in court with your questions, all of their jargon, all of the gibberish they give you will fall to the wayside if you just stick challenging the facts.
Yeah, right. Absolutely. It's funny you use the word gibberish. We'll talk about this more in detail. I know we don't have too much time left for Mary, but there was a judge this week when a ticket did get thrown out that he said that the motion that I had written that was filed was gibberish. I got to tell you, it's written at least an 8th grade level of English. So it's either the judge is illiterate or he's a liar.
Well, so Mark, you got to remember they're acting like 5-year-olds, so you're probably writing above their understanding.
I shouldn't. We used to joke around years ago. It's like, you really shouldn't write at a high school level. It's got to be at a 5th or 6th grade level. There, don't go over their heads.
The facts now are gibberish, huh?
yeah. I know. The Declaration of Independence. I quote that, which as a as a founder. It's gibberish. Well, of course, to them. It is gibberish. So, Mary, I know you don't have too much time. So with the time we got left, I want to get back into and do some of the role playing. I want to get back to the part where you're first in there, and I know it's a difficult thing to go in there, and there's a lot of tension, there's a lot of fear challenging a judge and a prosecutor. I get it, I understand. I've done it myself many times. I don't ever want to do it again, but I'm sure I haven't seen my last judge. I think the jurisdiction issue, of course, is paramount. If there's no jurisdiction, nothing else matters. Nothing else matters. It doesn't matter. It all has to be thrown. They have to have jurisdiction. And I believe that putting the judge in a double bind, while it may irritate him, as it would most people, I think it's necessary that the judge be put on the spot and be asked because you're asking if you're entitled to a fair hearing. And, are you presumed innocent, I think could come after that, if you don't want to initially get him with the conflict of interest stuff. Am I presumed innocent? Do you, sir, or ma'am, is it a man or a woman, do you know?
I believe the judges are men, the prosecutor is a woman.
Okay. So, you could say, but because they're going to ask if you're ready to proceed. Well, before we can proceed, there's a number of things I'd like to ask. Am I entitled to a fair hearing? Well, yes, of course. Well, do you presume me innocent, sir? And he's probably going to say, well, yes, of course. Well, my other question is, have you already determined, before anything has been heard yet, that I'm subject to the laws of the state of Michigan? This is not, I can't kid you, that this is not going to get the judge irritated. Okay, it will. Calvin, you can testify to that.
Oh, yeah.
I think anyone listening, whether they're no-staters type of people or voluntarists or not, people that I've presented this in, because I've done hundreds and hundreds of radio shows where I was a guest, and I've talked about these things, and they're like, "Oh my gosh, that's going to really irritate the judge," because you know that you're putting the judge in a very tight spot there, and he's in front of all these people. Well, what's he going to say? He may not answer you.
Now, he is a lawyer.
He is a lawyer. But Mary, so what I want to do, I want to take the position of the judge where I'll say, look, you're presumed innocent of the crime, Mary, and I'm not presumed. I haven't, but the laws are applicable to you. That it's fairly obvious.
So you're the judge and Kelvin's the prosecutor, and I'm in there, and he says what?
Well, you've asked me, the judge. We've gone through this scenario where you've asked if I'm entitled to a fair trial, and I said, yeah, you are, of course, ma'am. You are, of course. And then you asked me if I presume you innocent. And I said, well, yes, of course you're presumed innocent until proven beyond a reasonable doubt. Of course you're presumed innocent. And then you follow that up with, well, sir, before we can go any further, have you already determined, or have you assumed, maybe made the assumption that the laws of the state of Michigan apply to me already? And the judge, come back and say, well, yes, it's not. The laws of the state of Michigan do apply to you. That's why we're here.
And I will be smiling, as any prosecutor would.
Yeah.
So you basically call him on it, Mary. You say, well, what are those facts and who gave it to you? I mean, because if the judge is assuming it, then it's fair to challenge him on it.
Well, an easy way to do it, though, Mary, is to say, well, wait a minute. Now I'm a little confused. You said I was presumed innocent of the alleged crimes, and now you're saying the complete opposite. You've already presumed an essential element of both of the charges, that the laws are applicable. Am I presumed innocent or not? He's not going to want to admit, like some have, like Bugliosi, that it's a myth. He's not going to do that. He'd be contradicting. I mean, but either way, he's contradicting himself because he's already said you're entitled, that he presumes you innocent. So which one? So you just want him to clarify, sir. Now, which one is it? The laws apply to me, or I'm presumed innocent. Even at the least, if he just wants you to explain what in the world you're talking about, because you may honestly be confusing him. At least you're talking about it. He's not just running ramshot over you and refusing to discuss it. So. If I say I'm the judge, Mayor, I don't know what you're talking about. You are presumed innocent. I don't see where the problem is. How you're presumed innocent, but yes, the laws do apply to you. Where's there a problem there?
I wouldn't know what to say. I wouldn't know how to respond to that.
Okay.
Well, do you see the double bind?
The laws do apply.
But I already told you what would be a good way to say it. Is say, sir, I'm a little confused here. I don't really know what to say because I'm kind of confused.
Well, what Mark's pointing out is that you got him in a double bind here. Is that he said that you're presumed innocent, but by saying that you are within the state, that the laws are applicable to you, then he's also presuming you to be within the state, and that contradicts the presumption of innocence, because when you presume
because it's an element of the.
Do you see that double bind?
Yeah, the applicability of the laws is an element of the crimes.
So you have him in a good double bind, and it's hard for him to get out of that, but you want to hold him to that.
Well, there are two contradictory positions, Mary. If you're presumed... Okay, so you do understand that the two things are contradictory.
Yeah, because being within the state is an element of the crime, and if he's saying the laws do apply to you, and of course you're presumed innocent as well.
Jackpot.
Yeah, I think I understand that a little bit better now. Thank you.
Right, so he may not understand it either. You may be the first one to go in and do this with him, so he may honestly be confused. Now, the prosecutor is probably, probably doesn't understand it either, and may make an objection. I'm just trying to understand what's going on here. I'm not, and if they say something like, "Well, have your lawyer can explain to you," have the lawyer ask them the same question. But it's a double bind because they're contradictory, and there's a lot of social pressure on him to get out of this gracefully because of all the people that are there. The cops admire him. The prosecutors want to be him. He's the most, he's a little demigod there, and they all worship him. They will carry out his orders without a moment's hesitation. Okay, so he's in a very, very difficult psychological position here, and he may lash out at you because of it.
Yeah, and I'm definitely prepared for that as far as a bunch of different things that, I could be interrupted and called names and yelled at and threatened, and I'm definitely expecting that.
Well, yeah, you have to say it, but you're not prepared, and you agree you're not prepared yet to do this. You need to spend some time on this, and I'll do the best I can and answer questions and do more role playing. But I'm a pussycat compared to with these guys. I'm not gonna. I mean, I could give you an empty threat, and I'll try and but you can laugh it off. There, you can't. So you need to at least get to a point in the next few days where in the role playing, you may not have to be rapid fire, and you don't necessarily have to be, but you should be able to, in whatever circumstance we're talking about, be able to respond. So so I want to help. That's why I'm being critical, because what you have to really pay attention, because I was giving you the answers and things to say, and because of frustration or whatever fear. You're not able to access that, and so it's going to be 10 times worse if we
actually being there. Yeah,
actually being there. So that's why I tell you, if you can't, if you can't do it with me or Calvin or Vin or one of the other guys that are helping, yeah, you need some work. And so what I would recommend is go back in your history and look at other situations where you have with confidence and clarity of thought been able to defend yourself and say what needs to be said and reach your goal and get back to that, because you have those resources. We all have that. And if I was as good as Alistair Kinnear, boy, I could help you on the phone, but I can't. I'm not. But that's a start. You can do that. You've been in situations before where you've handled yourself pretty well, and you just need to be able to access that and have that available when you go in on Thursday, because you may have to do this yourself. So get with those guys, and we'll talk more off air, and we'll get together Monday and speak to this public defender and see if he's willing to play ball.
Sounds like a plan. I appreciate it.
All right, Mary, good luck, and we'll keep, let us know what's going on and what else I can do to help.
Right on. Thank you, Mark.
All right, thanks.
Thank you.
Thanks.